Hello, I'm John Trimbos, and this is program 4 in a 6-part series of programs for Acuity. If you haven't seen part 3, I would strongly suggest that you go back and watch part 3, because I'm now going to carry on from where I left off in the last program. So the topic is, of course, legal drafting, which is clearly a much more strict exercise than general business writing, because of course legal drafting could potentially come under judicial scrutiny, or certainly be the subject of a dispute, and it could be a dispute on interpretation. So of course you've got to make sure that the meaning is absolutely clear and watertight. And we finished off session 3 by redrafting that rather verbose property lease clause there. So moving on now to 3.2, some preliminary drafting stages. Now you may recall that program 3 started off in a fairly negative sort of way, looking defensively at negligence cases and things that go horribly wrong and pitfalls to avoid and so on. What we can now do is we can go into a more positive frame of mind and try and look at some best practice to guide you in the process of legal drafting. So preliminary legal drafting stages, 3.2, ask yourself these questions. A, what's the client want? And flowing on from that, can we use a standard form? Can we use a precedent, or do we have to do something bespoke from blank sheet beginnings? And I'm sure in 9 times out of 10 in the real world, the answer is no, we can use a precedent, we can use a standard form. And then you go, oh, thank goodness for that. You know, you may have to customize it, you may have to tweak it, but it's basically there. But every now and again, you will have to do something bespoke. You will have to do something specially tailor-made, and that's really what we're going to focus on in this session. Establish the facts, take instructions from the contract. What's the bargain? What's the deal? What's the duration? What's the major obligations? What's the money? You know, that sort of stuff. Some of you watching this program may well be in the world of disputes resolution, in which case the kind of, apart from pleadings, I suppose, the kind of thing you might draft a lot of is settlement agreements. And in that case, it is still basically what's the deal. Obviously, it'll be a bit different. It might include things like the extent and nature of the restrictive covenants and the gardening leave provisions and the details of the confidentiality clause and things like that. But it is basically what's the deal. Then do your first draft, then do some preliminary legal testing, and look out particularly for judicially defined language. So for example, we touched on this in our exercise towards the end of program 3, words that involve time like from and after and within so many days. If you just say a date and nothing else, then typically time will tend to run from the next day. So within 10 days of the 1st of January, time starts running on the 2nd. You can change it, so you can change from to, for example, from and including. So from the 22nd means time starts on the 23rd. From and including the 22nd means that time starts on the 22nd. So yeah, you can change it, and from and including is reckoned to be safer in the hands of clients. More judicially defined phrases. Well, we have best and reasonable endeavors, which I used a lot, and we did talk in program 3 about subjective words, and I did say that pragmatically you can use the odd subjective word here and there. And this is an example again where I think you can, because these apply to obligations to try to achieve an aim within the contract, but there is absolutely no guarantee of success, and they are all slightly different in meaning. Last program we saw one of the negligence cases was Whitman Tools and Schuler, and in that case Whitman Tools were under a best endeavors obligation to try and sell Schuler products in the UK. No guarantee of any sales whatsoever, but they had to do their best. Now, this is quite a neat little summary here from Rhodia International Holdings, where the court considered these expressions, best endeavors, reasonable endeavors, and all reasonable endeavors. And the court expressed the view that where a number of reasonable courses could be taken to achieve an aim, an obligation to use reasonable endeavors probably only requires a party to take one reasonable course and not all of them. So for the sake of argument, if there are three possible avenues you could go down to achieve this aim, if you're under a reasonable endeavours obligation, then you choose the most likely avenue to follow, but you don't really have to worry about the other two. So it's not that onerous an obligation. However, an obligation to use best endeavours probably requires a party to take all the reasonable courses he can. So in that case, if you're under a best endeavours obligation, you've got to follow all three avenues to try to achieve this aim, regardless of expense and inconvenience. This is subject to commercial sanity. So the courts have said expressly that you don't have to bankrupt yourself or you don't have to drive your business into liquidation. But no, subject to that, though, you've got to do everything within your power to try to achieve these aims. And the phrase that you often see in this context in textbooks is that you must leave no stone unturned. You've got to do everything within your power. And then the court went on to say that in that context, it may well be that an obligation to use all reasonable endeavours equates with best endeavours, and it may do or it may not. That did throw the cat among the pigeons at the time. But if a lot of people thought, oh, blimey, so all reasonable endeavours means the same as best endeavours. Well, it might do, but it might not. A few years ago, there was some quite high profile litigation involving the Chelsea Barracks redevelopment here in London. And the court considered the phrase all reasonable commercial endeavours. And first of all, it's decided that the word commercial added nothing. But the High Court there said that all reasonable endeavours depends very much on the circumstances. It depends on how reasonable or how unreasonable these ways are of achieving these aims. So yeah, if there are three eminently reasonable ways to achieve an aim, then you probably do have to do all three. If there is one that's really quite onerous and not but the other two are much easier, then it might just be the two easier ones, but not the really onerous one. It depends on the facts, and the High Court said the best way to resolve what all reasonable endeavours means is to seek a court declaration, put the facts before the court and seek a declaration. And I think everyone then pretty much decided that it wasn't worth doing that. And so pragmatically, I would say just stick to the other two. That's my pragmatic advice anyway. Then the sequence of operations should be logical. And I think following the timeline probably makes most sense, really, for a lot of legal documents. And then what I've also said is if another document's incorporated by reference, then retain a copy in a schedule or an annex. So in the case of the property law redraft that we did last time, there was a reference there to a 10-year buildings guarantee. I would wish to have the 10-year buildings guarantee in a schedule or an annex to my own commercial property lease, just so it's there. And then something we're going to return to, but I did say last time, if you do have to start from blank sheet beginnings, prepare an outline only, just scroll out the headings and the subheadings, juggle them into the appropriate order, just basically decide what clauses you need. And then only once you've done that outline, once you've created a skeleton to show the overall shape and structure of the document, do you then move on to the word-for-word drafting. Because otherwise, you might just miss stuff, like they did in Whitman, Tools and Schuler. Right, reviewing the documents. Now, use short sentences and where appropriate, tabulation. I would say all of this applies to where the other side had done the first draft as well. Actually go through it, and if something needs to be clarified or simplified, by all means do that. Now, what I've said is use punctuation like commas sparingly, if at all. And certainly in the property world where I come from, it is customary to avoid commas. Now, I don't mind commas in themselves. I think they're basically all right, even though I do come from the property world, but they can be tricky little things. And I think in contract clauses, it's better if you can do without them. Now, I'm just going to type an example out now. This is scurrilous rubbish. Somebody showed this to me years ago. I can't remember who. Sorry, there we go. Right, I'm going to type this out twice without any punctuation. And if you're feeling offended already at what I've just written, bear with me because this goes either way. This sentence is, sorry, I've missed out a word there. There we go. When I write this onto flip charts on a course, then this causes pandemonium. So this is unpunctuated. Woman without her man is useless. And I'm trying to say this as robotically as possible, by the way, to avoid putting any emphasis, because if I change my emphasis, if I change my inflection, that changes the meaning to the listener. But here we go, unpunctuated. If you throw this into a room full of people and you say, here you go, punctuate this sentence, most people stick in a couple of parenthetical commas like this, and you end up with version 1 that goes, woman without her man is useless. And then every woman on the course glowers at me. So I then move rapidly on to version 2, which needs a stronger pause here. Now it could be a colon or it could be a dash. So I've just put a dash in there. This one goes, woman without her, comma, man is useless. And then, yeah, certainly the last time I did this, this was in-person training as a city law firm here in London. Every female head in the room just went, they didn't even realize they were doing it. So yeah, so you can see same words, same order, totally different meaning. And the real killer there is, where does that comma go? Does it go before or after the word man? And because commas are so stylistic and discretionary in English, it makes the English language a little bit vulnerable to distortion like that. So let's have a look at a couple of examples now, a couple of contractual examples. The first one is fictional. The second one is a real Canadian case, which I'll tell you about. But we'll do the first one first. The agent will be entitled to commission at the rate of 15% of the commission received by the agency on all transactions concluded by the agent, which actually complete whilst the agent is in the employment of the agency. Now, it is ambiguous and it should be 2 sentences, in my humble opinion. But just the way that it is there, the way that it's drafted out, just have a think about it and imagine that you are the agent. Okay, so the agent is you, and you conclude the negotiations of a deal. So you negotiate a deal, you conclude the deal, but then you get headhunted and you leave. You resign, you leave, and you start a new job somewhere else. And after you've started that new job, that deal then completes. Okay, so it's your deal in the sense that you concluded it, you negotiated it, but legal completion happens after you've resigned and left. The question is, can you get your 15% commission on that last deal? So you did all the work, but completion happens after you've gone. Can you get your 15% commission? Obviously, during the coronavirus, I ran this course as an interactive course on Zoom an awful lot. And typically in the chat box on Zoom, I would get yes, no, yes, no, yes, no, possibly, or I don't know, help. Yeah. The reason for that is, let me go back to my scurrilous sentence. If you sandwich a phrase between 2 commas like that, in the minds of many readers, that does the same job as this. Parentheses. There you go. Woman without a man is useless. Okay, like that. So, going back to our sentence here, we have a phrase which actually completes, which sits between 2 commas, but I'm going to take out the commas and I'm going to put in parentheses around brackets instead. Now, I'm guessing most of you watching this program would have said, no, you can't, because most people say, no, you can't. But you see, I think you can. Imagine those 2 commas there are parentheses like that. So the agent gets 15% of the commission received by the agency on all transactions concluded by the agent, which actually complete whilst the agent's in the employment of the agency. Well, if you read the 2 commas as doing that job, I would say the answer is potentially yes. It's still ambiguous, I suppose, but it's a good arguable case, because that looks like an overarching clause, which actually completes. Whenever it completes, that triggers the entitlement to the commission. Yeah, I would say you probably get paid off. Now, let's restore the original punctuation. let's imagine that we had this typed up and then we think, well, hang on a minute, that second comma is a typo. We didn't mean to put that in there. So now look, I've taken the second comma out. And then the same situation. So you concluded the deal, but then completion happens after you've gone. Can you get your 15% commission? Well, if you take out the second comma, I would say, no, you can't, because the sentence then ends, which actually complete whilst the agent's in the employment of the agency. Without the second comma, then it looks to me like completion must take place while you're in the employment of the agency for this to apply. And of course, you've gone. You've resigned and you've gone. So then the answer is no. So that second comma there, after the word complete, that completely wrecks the clarity of that sentence. Whoops. So yeah, I would say commas best avoided if you possibly can. And I would split that one up into two. So there it is again. Sorry, I seem to lose the paragraph there. At the end of line 2, where it says on all transactions concluded by the agent, I would then put a full stop. So sentence 1 gives you your basic 15% entitlement. And then in a separate sentence 2, I'd jump one way or the other. So then the second sentence would either say, completion must take place while the agent's in the employment of the agency for this clause to apply, or alternatively, completion must take place within 6 months or 3 months or whatever of the agent leaving the agency. So whichever way you jump on that second issue. Now that was synthetic, just to illustrate the point. The second case is a real case. This is Telecom Decision CRTC 2006-45, an agreement for access to telecoms equipment, provided that the agreement, here we go, shall continue in force for a period of 5 years from the date it is made, and thereafter for successive 5-year terms, unless and until terminated by 1 year's prior notice in writing by either party. Right, just scrutinize that, just have a little think about that. And then the question I'm going to pose now is, at what point can you, on the timeline, can you serve your 1 year's notice in writing to terminate? And in fact, I'm going to do this onto the flip chart, sorry, the whiteboard, whatever it's called. Just clear that. Because this is a contract which goes in 5-year increments, excuse the wobbly line here, but it could just be a 5-year contract, but it could roll over into 10 years, or it could go to 15 years or even yet longer than that. There you go. Now, the common sense answer, and I now know for a fact this is what the parties intended, is this. So it's a contract that goes in these 5-year increments like this. So what the parties intended was this: at year 4, you serve a year's notice to terminate, and then that ends the contract in year 5. And then if the contract rolls over, then the same would apply in year 9 and year 14, etc., etc. But one of the parties got a better offer and they wanted to wriggle out of the deal, and they succeeded. And they said, no, that last bit, unless and until determined by 1 year's prior notice in writing by either party, that's an overarching clause, that bit after the comma at the end there, and that allows either party to serve notice to terminate at any point in year 1. So theoretically, after 364 days, you can serve a day's notice to terminate, and that ends the contract at the end of year 1. And it's a clever little argument. It's a very clever argument. Hats off to them. And at first instance, the court in Canada agreed. I think it's incomprehensible myself, and I think the other side could have appealed, but I think they had another client lined up, so they just took a commercial decision to walk away. But yeah, you can see there it's another long sentence with 2 commas in, and that's almost asking for trouble. And you see, I would split it up. I would say, this agreement shall continue in force for a period of 5 years from the execution date, the start date, and thereafter for successive 5-year terms, full stop, and then you could choose whether you needed that comma or not. I think you could probably get rid of it. And then in a separate second sentence, I would say, either party may terminate, may serve the first notice to terminate at the end of year 4. And then I would say in a separate sentence, if the contract subsequently extends into further 5-year periods, then the same provisions, termination provisions, apply in year 9 and every 5-year anniversary thereafter. And then if you did want to put in a break clause after any year, well, you can stick that in as well, but you put it in as a separate sentence. And that's the key to all of this, is each separate idea takes a separate sentence like that. And again, that's the best way to achieve clarity like that. I think I know the answer to this case now, actually, because in all the press coverage of the Oakhurst Foods case, the American case I showed you at the beginning of program 3, there was a reference to this Canadian decision. And apparently, well, I mean, I can't remember where the article was, but according to this article, the original version of the contract was drafted in French, and of course, French and English are both official languages throughout Canada. And yeah, so the original draft was in French, and that one was quite clear that the provisions, the termination provisions, only applied in year 4, year 9, and so on. And it was a bad translation that introduced the ambiguity. And I've always wondered about the wording, because it's strange vocabulary, isn't it? This agreement shall continue in force for a period of 5 years from the date it is made. What the hell is that? You make a contract. I think it means the execution date, actually, from the date it's executed. So it was a poor translation. Absolutely extraordinary, but there we go. Again, though, an object lesson in how easy it is for ambiguity to creep in if you're not careful. Okay, test all comments on your draft as if they'd been included in the first draft, and for legality and clarity, and if there's any knock-on effects for cross-referencing and things like that. Now here we have the typical structure of a legal agreement, which I'm sure you don't need me to point out. Just out of interest, though, I know I mentioned this particular document in the first program, but I'm going to mention it again. There we go. The Acuity law house style for documents. Look at that. Table of contents. There we go. Background, recitals, and so on. So, you know, that structure hardwired into your precedents there. Right, now, I think we've actually talked about most of this stuff during the last program in a bit. So aids to readability, parts, headings, schedules, putting detailed stuff into schedules. In that property example that we redrafted, putting the 10-year property guarantee into a schedule. Definitions we've certainly looked at, and so on. And look at the presentation as well. So indentation, index, table of contents, it's all there in your house style documents, which is obviously really great. And then what I've said is don't over-rely on precedents. And in particular, I think a lot of lawyers, given a deal that sort of half looks like a precedent, they'll probably go to the precedent and try to kind of twist it to fit the deal. But often it's better not to do that. It's often better just to start from blank sheet beginnings and build it up from scratch and do something really bespoke. But of course, people look at the blank screen or the blank notepad and think, oh, hell, where do I start? And the answer is, as I've said on a couple of occasions now, is you start on the, you start with a skeleton outline. You just start with the whole shape and structure of the document. And only once you've done that, and you've made sure you've got everything that you need to make a workable agreement, only then do you actually do the word-for-word drafting, and then it pretty much writes itself. Now, to illustrate this, I've got a rather eccentric exercise which I'm going to talk you through, and then I'm going to get you to think through what's needed for this contract while I draw up a skeleton outline onto the whiteboard. So The idea is this is a very eccentric contract, and no law firm that I know would have a precedent for this. So you would have to start from blank sheet beginnings and create something really bespoke from scratch. So you've been asked to draft a contract between two blokes. We have a Mr. Rolls and a Mr. Royce, and it relates to the hiring out in the course of Royce's car hire business of a classic Bugatti owned by Rolls. By the end of May, Rolls will deliver his 1923 Bugatti in full working order, free from encumbrances and so on. So, by the way, a 1923 Bugatti, probably worth over £1 million. You know, seriously antique. It's not just any old classic car. I mean, it is a kind of unique antique artifact worth, yeah, well over £1 million, I would have thought. The venture will run for at least 6 years from the 1st of June, termination year's notice by either party. So on that basis, first notice to terminate can come at the end of year 5 years in, year's notice, end the contract at year 6. But it says at least year 6, so then it can carry on. If it's a successful arrangement, then they could decide to carry on beyond year 6 on a rolling basis. Now, the car is divided between the two guys during the period of the contract, so different things happen in different months of the year. From the 1st of June to the end of December, the car will be hired out by Royce to third parties. During January, he'll service the car. From the 1st of February to the end of May, Rolls gets it back just to mess around with, and then the whole cycle starts all over again. Royce has got a lot of obligations, so he's got to maintain and repair the car, service the engine once a year. The maintenance obligations apply at the end of the term, so whenever the contract ends, it always has to go back in tip-top condition to the owner. Now, money, Royce pays to Rolls 10% of booking fees receivable within 2 weeks at the end of each calendar month, and this is regardless of whether Royce has been paid by the end user or not. It's the taking of a confirmed booking that generates the obligation to pay the money. Royce has also got to insure the car and have public liability insurance and pay all road taxes and garage the car all year round. So there's a lot of obligations there, but on the other hand, he is getting 90% of the money. So I think that is probably fair enough in that case. Now, what I've said here is draft out a framework showing the headings for the clauses in the contract, and then a little synopsis of each clause, well, only if necessary. Obviously, you don't need to do this on paper. If you don't want to, you can just do this in your head. But what I'd like you to think is, what is the shape and structure of the contract? What would the whole structure of the contract look like to reflect these instructions? Imagine one of the guys has come to you for representation, and I don't think it matters terribly much. Just choose your client. Imagine he's come to you and has said, I've got a new business venture. I need you to represent me, and I need you to do the first draft of the contract. Now, what I've also said is list any additional clauses that would benefit the contract for either party. There is lots of scope for nice to have stuff in here, things that would enhance the contract and make it a better contract. So if you have any bright ideas, by all means, throw those into the mix as well. But more seriously now, there are 3 fairly serious omissions in these instructions. There are 3 gaps in these instructions. And what you've got to do also is put your serious lawyer's thinking hat on now and think, okay, what issues have the clients not thought about? So imagine that Rolls-Royce are not lawyers, they're just business people. One of the guys has come to you with a pretty decent set of instructions, I think, to be fair, but they haven't thought of everything. And you've got to plug the gaps. You've got to think what's going to be necessary to complete the contract and make it workable. And I'm going to give you 3 hints now of greater or possibly lesser usefulness to bounce you in the right direction. So hint number 1 is, I mentioned that a 1923 Bugatti would be a unique asset. The original Bugatti company did not last for very long. It just existed for a few years in the 1920s and 30s, and then it went bust. And each car that it produced was absolutely unique. These were not serious production cars at all. Typically, Bugatti would build the engine and the chassis. Then the design of the body would be contracted out to an external coach builder who would design a unique body to the specification of the owner. So, bearing that in mind, if the car were to be destroyed in a fire or written off in an accident or something, well, you get your insurance payout. So the owner gets the value of the car through the insurance, fine. But just think to yourself, what happens to the contract? Can you even carry on the contract if the car no longer exists? That's issue number one. Issue number two is think back to the Whitman Tools and Schuler case. What did they miss there? Is that going to be of relevance to us here? And hint number three is this is quite a long contract. This is not a quickie sale and purchase type arrangement. This is a decently long duration, 6 years plus. It creates quite genuinely a working relationship between the two parties. And you really should talk to the client quite seriously about the sort of clause that might iron out any hiccups in the working relationship, if you kind of get my drift there. Now, those are the three essential gaps that you need to plug. Like I said, there is scope for nice to have clauses as well that would make it a better contract. Not bad if you miss them, but would make for a better contract. And I'm just going to run one idea past you of a nice to have clause, which is a break clause, maybe halfway through. So 6 years, quite a long time. So possibly a break clause at year 3. From the owner's point of view, it gives them a bit of flexibility. I mean, classic car prices for some reason spiked during the Corona pandemic. They seem to be settling down now, but like if there was another spike in prices of classic cars, then Rolls could then take advantage of that, exercise the break clause and sell the car at a profit, possibly. From Royce's point of view, I think it makes equal sense, because if the car turns out to be a bit of a commercial turkey, if it's so esoteric or so expensive that people just aren't hiring it, well, then I don't think Royce would want to be on the hook for maintenance and insurance and everything else, garaging, etc., for 6 years if the car isn't actually earning him any money. So if the car turns out to be a bad commercial proposition, then I would say a break clause maybe halfway through or even a couple of years into the contract could be a good idea for Royce. Okay, so by all means stop the tape. Stop the tape, I'm showing my age here, stop the program. Have a little think about it. And then when you resume, you can watch me draw up a skeleton outline of this contract on the whiteboard. So on the basis that you've now had a chance to think this through, I'm going to draw up a skeleton outline onto the whiteboard now. And a lot of, I mean, the whole shape and structure, a lot of this is going to look really quite predictable. So date, parties. I normally write recitals, but your house style has the more modern word background, which I suppose I ought to use. In fact, I'll put some numbering in as well. Just bear with me. 1, 2. Okay, so there you go. Date, parties, background. Now, some of the stuff kind of does have a customary place, and some things you just have to take a view on. But I would say definitions definitely belongs next, and yeah, you could definitely have definitions there. Then I would put duration of the contract in, and then that could be, so what I'll do is I'll put a little note there. So 6 years plus, and then you could also put in the divisions of the year, the different months of the year, and the break clause and so on. Okay, so duration. then I'm inclined to put money or payments next. I mean, you could put that in as part of Royce's general obligations, but I think money is such a high priority to, well, both sides in most commercial agreements. I would say that money payments, the payments bit, goes in next. Now, Royce's obligations, I mean, basically just to deliver the car in good condition every year. I mean, I suppose you could then add in something about not doing anything stupid with the car in the meantime, but I think it's pretty much implicit in that. Then we have Royce's obligations, which are going to be much more extensive, of course. So all the stuff about, I won't write it all in, but all the stuff about garaging and maintenance and so on. Excuse the typo there. This is what happens when I try to multitask on Zoom. Royce's obligations. Warranties and indemnities, I could certainly see scope for. I mean, Royce would probably want warranties that it is Royce's car and that he can deal with this in this way. Indemnities, I mean, for Royce's point of view, I mean, a lot of things like parking fines and things like that, or speeding offences and so on, a lot of that boomerangs back to the owner of the car. So I think he would want to have indemnities against people racking up penalties and things like that. So you can see the whole thing starts to build up from there. So we have their mutual obligations. Now, item 10 is going to be one of the major emissions there. And in fact, the other two emissions are typical boilerplate stuff. I realize I am slightly cheating here by putting boilerplate, but there's all the standard stuff about jurisdiction and stuff like that, all the standard form stuff. And you see the beginning and the ending of this contract, I reckon you could probably borrow from other precedents. It's the bit in the middle that would require the original drafting. Then we have attestation. And then schedules. You could have like schedules of approved insurers because of its specialist nature, the maintenance regime and things like that. So, it's kind of fairly standard form stuff, but obviously there's a lot of detail under Royce's obligations there. Now, the thing is, by not getting bogged down in the word-for-word drafting, this does free up our minds to think more holistically about what we actually need to complete the contracts and to make it workable. Now, I said that two of the missing clauses are typical boilerplate issues, and the other one is item number 10. Item number 10, I bet you would have spotted straight away, which is breaches and remedies. And there is certainly, forgive me while I just do this laboriously. There you go, breach. I haven't typed that too badly. Yeah, breaches. I could certainly imagine major and minor breaches here, especially from the owner's point of view. So, for example, if Royce is a little bit late sending the monthly payment through, well, what the hell, just pay some interest on the outstanding sum. But on the other hand, if you find out that Royce has been letting out the car to inappropriate people, or he's been neglecting the servicing and maintenance requirements, then that would be more serious. If he fails to renew the insurance, if he let the car go uninsured, that would be an absolute disaster, and I would want to terminate the contract straight away. So that was the Wickman, Tools and Schuler hint, major and minor breaches, definitely. On the subject of terminating the contract, the destruction or the writing off of the car, if you categorize, whoops, that's supposed to be an M. This pen thing is badly misbehaving. Force majeure, there you go. If you categorize the destruction or the formal writing off of the car as a force majeure event, I would say that's the best way to deal with that, because if the car is gone, the car is gone. You cannot replace it. You could get a replica, but not the real thing. If you had something like a 1950 Bentley Continental and that was written off, you could probably find a 1950 Bentley Continental at auction somewhere around the world and replace it. But in this case, you can't because of the car's unique nature. So I would have said categorize that as a force majeure event. And then my last hint was all this stuff about ironing hiccups in the working relationship. And that was a rather unsubtle hint about incorporating an ADR clause, alternative dispute resolution clause. And then obviously you'd want to have a chat with the client about what sort of ADR clause you might want to incorporate. So I would have thought in this case, possibly a mediation clause rather than a fully blown arbitration clause. But obviously there are different types of ADR available, and, you know, chat it through with the clients like that. So that kind of makes for a workable contract now. Nice to have stuff. Well, sometimes people dial in minimum ages of drivers, requirements of drivers to have clean driving licenses, mileage limitations, acceptable uses. So use the car on the road only, don't enter it into a vintage off-road rally or something, or the poor thing would probably shake itself to pieces. Sometimes people dial in the right for Rolls or his accountants to have access to the books, access to the financials, to make sure that he's getting everything that he's entitled to, and so on. Lots of nice to have stuff there. Not essential, not a disaster if you miss it out, but again, if you just think about it on a macro level like that, then you stand a much better chance of spotting the missing clauses or additional clauses that would enhance the whole thing and make it so much better. Okay, that's the end of that little exercise. I've got one more exercise to show you in the booklet. This will take your breath away. And in fact, you'll have to look at your own copy of the notes, because look, I can't get this onto one screen. This is one sentence from start to finish. I mentioned in the second program, the Plain English campaign website. Want to have a look at it, plainenglish.co.uk. People send to the Plain English campaign examples of mad sentences and things like that. And this is a sentence. This is one whole sentence that fills up a page of A4, which is, it's almost like a work of art, really. I mean, it takes a serious talent to fill up a whole page with one sentence, but they did it. This looks American to me, because it's full of references to attorneys, but obviously I've no way of knowing that. So the chances of you receiving a newly drafted sentence of this kind of length and nature, fairly limited, I would have thought, although you never know what life might throw up. But it is more likely that you might have to interpret an old deed or an old insurance schedule or something like that. And certainly if you do have to interpret old sets of restrictive covenants or things like that, you may well see a sentence of this length and nature, and then you'll have to take it apart and understand it and advise the client on what it actually means. So this is going to be time for you to pause the program again, probably for several minutes while you work your way through it. So what I'd like you to do is just read through that and just work out in your own mind what it means. What's it saying? How many clauses should it be? Not sentences. I mean, the answer to that is quite a few. But how many whole contract clauses are buried in this? So pause the program, have a little read. In the meantime, I have got a plain English redraft, which I'm going to show to you. So have a little look, and when you're ready, turn the program back on. Okay, I'm assuming that you have turned the program back on and that I'm back again. So I'm just going to open up the redraft, my plain English redraft of that contract clause, which has possibly been driving you mad for the last few minutes. Here we go. Just let me share my screen. It is an excerpt from a sale and purchase agreement, as you will probably have worked out, where the buyer is buying something in installments And then somebody has pledged land by way of security, and it could be the buyer, could be a third-party guarantor, absolutely no idea, could be one or the other. So land has been pledged as security. And then the top part is talking about events of default. So we'll have a look at the original wording in a minute, but I would personally say if the buyer defaults, the seller may declare due, and then it says the entire amount owing under the contract plus penalties and interest and whatever, so everything becomes payable up front. I have often seen that expressed as a defined term, the contract sum, which I think is quite neat. So the seller may declare due the contract sum, and then he has two remedies potentially. And the first one is very dodgy, which is enforced conveyance of the land in settlement. That I'm sure would be struck out as a penalty on this side of the Atlantic because the value of the land could be way in excess of the contract sum. So I don't see that surviving judicial scrutiny over here. May or may not be okay in the relevant US state, but I've no idea. So we'll just assume that that would be struck out. Or the second one, though, is more likely to sell the land or part at auction, which is far more likely, of course, because he wants his dosh. Then it goes on to talk about sale at auction. So if the seller decides to sell the land, he must do three things. There are three major obligations buried in that sentence, and the first two are relatively easy to divine. The third one is a load of mushy old rubbish about doing the best for all concerned and so on. And I've paraphrased that into a best endeavors obligation, which I think would work pretty well, actually. So if the seller decides to sell the land, he must A, advertise an auction sale in a local newspaper for at least 3 consecutive weeks, B, comply with all bylaws, and C, use his best endeavors to achieve the highest sale price, so maximize the money. And then there is another idea here, which is easy to miss, but I think you need to express it, and it could be a separate clause, or it could be a separate sentence within this clause. If an auction buyer defaults, the seller may re-advertise the auction sale. And I think you need to say that because if an auction buyer does default, clears off and leaves you high and dry with the money, high and dry with the land, then you're stuck with it. So you've got to be able to reactivate the auction sale and keep on doing that until you get the money in the bank. And then finally, you can see there is a logical structure buried in here somewhere, which is the application of the proceeds of sale. If the land is sold, the seller must apply the proceeds in the following sequence. And then we get what's often called a waterfall clause, where the money cascades down, and in sequence you pay off the auction and conveyancing costs, then the contract sum, then any other liens or charges over the land, and then finally any surplus goes back to the buyer, the owner, the guarantor, whoever it was that pledged the land in the first place. So that's what I would do to it. Obviously, the original style is a bit different, actually. So if you are faced with a sentence like that, what I would do pragmatically is this. First of all, print it off. Don't do what we're doing now. We're doing it all wrong. So don't look at it on the computer screen because you get a headache. You probably got a headache now. So print it off. Have a pen handy and be ready to mark it up. And what you need to do is you need to read through it carefully, and then look out for connecting words and just think, where does one idea end and then another idea begin? And very often you will find connecting words like then or provided that or something like that. And basically you just put in a slash or something. Just think, or an asterisk, just think, where would a sensible person put a full stop to split it up, the way that I split up that property lease clause, for example. And then also look out for two things. Look out for capital letters. Very often connecting phrases like provided that will be capitalized, and that will give you a clue as to something new beginning. In this case, though, it's the waterfall clause, as we will see. And also look out for lists. So if you see ABC or 1, 2, 3 popping up in running text, very often that's the start of something new as well. Now, I'm not going to read through it line by line, I promise you, but we'll just skip through it. Typically, instead of the nice short word if, it starts in the event that the purchaser defaults in the payment of any installment of purchase price, taxes, insurance, interest, and so on. Then on line 3, it says the seller may at his option. Look, here comes our list. A, these are our two remedies. A, declare immediately due and payable the entire balance, and then basically steal the land. And then if you drop down half a dozen lines, you'll find a B, look, or B, sell said land and premises or any part thereof at public auction. So those are our two remedies: grab the land, sell the land. But then on line 10, it goes on in such manner, at such time and place, upon such terms and conditions. And I would pause there and I would put my first slash after the word public auction, because that to me is the end of part one. Part one says there's been a default and then there are these two remedies, A and B. But now the middle bit is talking about the mechanics of the auction sale. So then it talks about advertisements in local newspapers and compliance with bylaws and so on. That's all the detailed stuff about how to conduct an auction sale. And then, like I said, capital letters, because look, capitals, first, second, third, last, and from the proceeds of sale, first, to pay all proper costs and charges and so on. Second, the amount remaining unpaid, the contract sum. Third, liens of record against the property, and then last, the remainder of the proceeds to the vendor, heirs, whatever. So yeah, that's our waterfall clause there. So those, yeah, I would say 3 major clauses there, well, as you've seen. But yeah, look out for those things. Look out for lists, look out for capital letters, but basically just mark it up. Just think, where would a sensible person put in a full stop? Then you can start to break down the ideas. Don't be intimidated by the length of a sentence like this, because they're just words. And the words will express ideas, and these ideas will be rights, obligations, time limits, conditions, things like that. There's a lot of them, but if you print it off and you mark it up, then you can take it to bits, and then you can understand what's going on. Yeah, I mean, just imagine that a client has got in touch with you and has said, oh, we've just bought an American company. We've got a new American subsidiary, and that American subsidiary is subject to this contract. Can you read it and understand it and tell us what it means? And I bet you can. I bet you can actually, and quite honestly, if you can read and understand that rubbish, then you can read and understand absolutely anything at all, and I'm absolutely sure that you can. So that brings us to the end of legal drafting. And there are 2 more programs in this series, which are much more focused on proofreading for errors. I hope to see you for those. In the meantime, if you are doing any heavyweight legal drafting, do bear in mind these principles, because they very much keep you on the straight and narrow. Very good ways of avoiding ambiguity. So good luck with all of your drafting endeavors, and I will see you again soon. Take care. Bye.